Welcome to the California Department of Insurance's video presentation, The Dispute Resolution Process for Workers' Compensation Insurance Policyholders. This video presentation will discuss the dispute resolution process that is available to workers' compensation policyholders, the types of workers' compensation policy disputes the insurance commissioner will decide, the types of workers' compensation policy disputes the insurance commissioner will not decide, how to initiate the dispute resolution process with an insurer or the Workers' Compensation Insurance Rating Bureau or WCIRB, how to appeal an adverse decision by the WCIRB or insurer to the California Department of Insurance's or CDI's Administrative Hearing Bureau or AHB, general hearing procedures, and how to get additional reference material about the dispute resolution process. Throughout this presentation, the terms policyholder, employer, and insured will be used interchangeably. This video provides you with basic information about the dispute resolution process for workers' compensation insurance policyholders and general administrative hearing procedures. It is not legal advice, but merely provides information that may help you understand the dispute resolution process and administrative hearing procedures. Under California statutes and regulations, all workers' compensation insurance companies doing business in California and the WCIRB are required to provide policyholders with a dispute resolution process. The regulations also require that the policyholder initiate the dispute resolution process with its insurance company or the WCIRB before bringing the dispute to the insurance commissioner for a final decision. The purpose of this requirement is to give the parties the opportunity to thoroughly investigate the causes of the dispute and reach a possible settlement. However, if a settlement cannot be reached, the parties will have developed a more thorough factual record if the employer elects to pursue the matter at the CDI. After an insured exhausts the insurance company's or the WCIRB's dispute resolution process, the insured has a right to appeal an adverse decision to the insurance commissioner by filing an appeal with the Administrative Hearing Bureau at the California Department of Insurance. Appeals filed with the CDI are ultimately decided by the insurance commissioner. Typical disputes the commissioner will decide include whether an insurer correctly assigned an employer's payroll to the correct classification, whether an insurer correctly reported loss data to the WCIRB, whether an insurer correctly applied an experience modification to a policy, whether an insurer correctly applied a surcharge or other rating plan factor to the policy. The commissioner also will decide whether the WCIRB correctly assigned classifications on a WCIRB inspection report and whether the WCIRB correctly calculated an employer's experience modification. The insurance commissioner will not decide disputes that are based on contract law or that typically are decided in a civil court or by another administrative agency. These types of disputes include whether an employee is exempt from coverage under a workers' compensation policy, whether a worker is an employee or independent contractor, whether an insurer properly adjusted an individual claim for workers' compensation insurance benefits, or whether a premium bill that does not involve a classification, experience modification, or surcharge issue is correctly calculated. If an employer disputes the WCIRB's decision, action, or inaction, the employer initiates the WCIRB's dispute resolution process by submitting a written inquiry to the WCIRB. The WCIRB will review the inquiry and send the employer a written decision. If the dispute remains unresolved and the employer wants to pursue the matter, the employer must next submit a written complaint and request for action to the WCIRB. The WCIRB will acknowledge the complaint and send the employer a detailed written decision that includes a notice of the employer's appeal rights. At this juncture, if the employer disputes the WCIRB's decision on the complaint, the employer may either request the WCIRB reconsider its decision, or the employer may file an appeal with the CDI's Administrative Hearing Bureau. An inquiry to the WCIRB must be in the form of a letter from the employer. You can mail the inquiry to the WCIRB or submit the inquiry as an attachment to an email to the WCIRB. The inquiry should include the name of the employer and the insurance company who issued the policy in dispute. Identify the policy by providing the policy number and policy period, and provide the WCIRB with a detailed explanation as to why you believe the WCIRB's decision, action, or inaction is wrong. The inquiry must be received by the WCIRB within 12 months after the expiration of the policy, or within 6 months of the issuance of an experience modification, whichever is later. The WCIRB will begin its investigation of the inquiry and may request that you supply additional information within 60 days after the WCIRB receives the inquiry. Within 90 days after the WCIRB receives the inquiry, it will send you a response. If the employer disagrees with the WCIRB's decision on the inquiry and wants to pursue the dispute, the employer must submit a written complaint and request for action to the WCIRB within 60 days from the date the WCIRB serves its response to the inquiry. If the WCIRB fails to serve a response to the inquiry within 90 days, the employer must submit a complaint and request for action within the following 60 days. The complaint and request for action may be in the form of a letter from the employer and should contain the complete name of the policyholder, the policy number, and the policy year in dispute. The employer should provide a detailed explanation of why the WCIRB's response to the inquiry is wrong and provide the WCIRB with any supporting documents. Once the WCIRB receives a complaint and request for action, the WCIRB must acknowledge it within 30 days. The WCIRB must send the employer a written decision on the complaint within 60 days after the acknowledgement. If an employer disputes the decision, action, or inaction by its workers' compensation insurer, the first step in the dispute process requires the employer to submit a complaint and request for action to the insurance carrier's designated representative. The insurance company must acknowledge the complaint and mail the employer a decision on the complaint that includes a notice of the employer's appeal rights. If the employer disputes the insurance company's decision on the complaint and request for action and wants to continue with the dispute resolution process, the employer must either request that the insurer reconsider its decision, or the employer must file an appeal with the California Department of Insurance's Administrative Hearing Bureau. To start the dispute resolution process with the insurance company, the employer must submit a complaint and request for action to the insurance company's representative, who is designated to accept complaints and requests for action. Please note, unlike the WCIRB's dispute process, the employer is not required to submit an initial inquiry to the insurance company. The regulations also do not set a specific time limit for submitting a complaint and request for action to the insurer. However, the employer should do so as soon as possible after the dispute arises, because other time limits may apply if there are related civil actions associated with the dispute. A complaint and request for action may be in letter format and should include the complete name of the policyholder, the policy number, and year in dispute. Provide the insurer's designated representative with a detailed description of the dispute with supporting documents, if any. Contact information for the insurance company's designated representative for the receipt of complaints and requests for action is listed in your insurance policy. Refer to the policyholder notice entitled Your Right to Rating and Dividend Information under the section labeled Our Dispute Resolution Process. Alternatively, contact information for your company's designated representatives can be obtained from the CDI's website at www.insurance.ca.gov. The following demonstration shows you how to access the CDI's website for this information. Go to the CDI's web homepage and select the Consumer tab. A selection of links will appear. Select the link to company and agent broker information. From the column located on the right side of the page, select Workers' Comp Company Contacts. Select the link to the list of workers' compensation companies in the text as shown. Locate your workers' compensation insurance company from the alphabetical list and select the link entitled Info after the name of your insurance company. Your workers' compensation company profile page will appear. Go to the links located in the column on the left side of the page and select Workers' Compensation Complaint and Request for Action and Appeals Contact Information. Contact information for the person or persons designated to receive complaints and requests for action and appeals will appear. This information is provided to the CDI by your insurer. If you have any questions about the information shown, please contact your insurer or the Administrative Hearing Bureau. When the workers' compensation insurance company receives a complaint and request for action, it must acknowledge receipt of the complaint in writing within 30 days. The insurer will then review the complaint and may request additional information from the policyholder in order to complete the insurer's investigation. The insurer also must send the employer a written decision on the complaint and request for action within 60 days after acknowledging the complaint. The insurer's decision must address each issue raised in the complaint, include a notice that the employer may request the insurer to reconsider its decision or to appeal the decision to the CDI's Administrative Hearing Bureau. The carrier's decision also must provide the employer with the address of the CDI's Administrative Hearing Bureau. After the WCIRB or insurer mails its written decision on the employer's complaint and request for action, the employer may request that the Workers' Compensation Insurance Company or WCIRB reconsider its decision, or the employer may appeal the decision on the complaint to the insurance commissioner. If the employer requests the WCIRB or insurer reconsider its decision, the employer's request must be in writing and must be submitted within 30 days from the date the WCIRB or insurer served its decision on the complaint and request for action. The WCIRB or insurer must serve its decision on reconsideration within 30 days after being served with the employer's request for reconsideration. Alternatively, the employer may file an appeal from an adverse decision or inaction on a complaint and request for action. An appeal may be filed from the following: a written rejection of review of the complaint, a written rejection of the complaint, failure of an insurer or the WCIRB to grant or reject a review of a complaint, and failure of an insurer or the WCIRB to timely grant or reject a complaint. An appeal to the insurance commissioner from a written decision on a complaint and request for action by an insurer or WCIRB shall be filed within 30 days after the insurer or WCIRB rejects review of the complaint, or within 30 days after the insurer or WCIRB serves its decision rejecting the complaint. If an insurer or WCIRB fails to serve a written decision, the employer shall file an appeal within 120 days after it served the complaint and request for action upon the insurer or WCIRB. If the employer served a request for reconsideration, it must file the appeal within 30 days after the WCIRB or insurer served its decision on reconsideration. If the insurer or WCIRB fails to serve a written decision on reconsideration, the employer must file the appeal within 60 business days after service of the request for reconsideration. An appeal shall be in writing. The appeal can be in a letter format, or you can download and complete the appeal form on the CDI's website. The appeal must include the following information: the name, address, telephone, and fax numbers of the appellant, and the appellant's representative, if any. Copies of correspondence between the appellant and the insurer and/or WCIRB regarding the subject of the appeal, including the complaint and request for action, and the decision from which the appeal is taken. The appeal must include a statement as to why the appellant believes the insurer's or WCIRB's decision or action is wrong, and any documents which support the appellant's position which are reasonably available to the appellant at the time of the filing of the appeal, and upon which the appellant intends to rely at the hearing. The appeal also must include a statement that the appellant has or has not filed a complaint with the CDI requesting review of the same transactions, actions, or omissions which constitute the subject matter of the appeal. If such a complaint has been previously filed or is pending, the appellant shall provide the CDI's assigned file number. Appeals to the Insurance Commissioner must be filed with the Administrative Hearing Bureau, located at 45 Fremont Street on the 22nd floor, San Francisco, California. The employer must file with the AHB an original and one copy of the appeal. The employer must serve by mail the insurer, whose policy is in dispute, and the WCIRB, with copies of the same documents filed with the AHB. The employer must attach a proof of service to the appeal it files and serves, attesting to the fact that the WCIRB and the insurance company were served with exact copies of all documents filed with the AHB. A proof of service form is available for download on the CDI website. When an appeal is filed with the AHB, the Chief Administrative Law Judge will acknowledge the appeal and provide information on how to perfect the appeal if it is not complete, or issue an inception notice if the appeal is complete, and assign the appeal to an Administrative Law Judge, or ALJ. Within 19 days from the date the inception notice is served, the WCIRB and insurer must file and serve their responses to the appeal. However, The insurance commissioner may issue an order summarily denying the appeal without a hearing if the commissioner has information on the subject from which the appeal is taken and the commissioner believes that a reasonable basis for the appeal does not exist or that the appeal is not made in good faith. For example, the dispute is one over which the commissioner does not have jurisdiction. The employer failed to timely initiate or complete the WCIRB's or insurer's dispute resolution process. The employer did not perfect or file a timely appeal. The administrative law judge assigned to the appeal will conduct a telephone status conference after the responses to the appeal have been filed and served. During the status conference, the ALJ will review possible hearing dates, the issues on appeal, pre-hearing and evidentiary hearing procedures, and answer questions the parties may have about hearing procedures. The ALJ may issue an order following the status conference, instructing the parties to complete certain pre-hearing tasks. Before the evidentiary hearing, the ALJ will issue a notice of hearing that notifies all parties of the date, time, and place of the hearing, identifies the law governing the hearing, sets a schedule for filing pre-hearing documents, such as exhibits and witness lists, and describes post-hearing procedures. A hearing is similar to a civil trial, but without a jury. You may, but need not, be represented at the hearing. If you choose to be represented, that person need not be an attorney. The administrative law judge assigned to your case will base his or her proposed decision on the evidence presented by the parties and admitted into the evidentiary record and on the governing law. Evidence includes testimony given under oath by you and other witnesses, and documents that contain information about the case. The hearing will be conducted at the CDI's Administrative Hearing Bureau at one of the following locations most convenient for the parties: in San Francisco at 45 Fremont Street, or in Los Angeles at 300 South Spring Street. The AHB provides an impartial forum to present your case and to be heard. The ALJs at the AHB hold themselves to the highest ethical standards, providing professional, competent, and high-quality services while treating everyone with dignity and respect. The workers' compensation appeal hearings are conducted pursuant to procedures set forth in the California Code of Regulations. These regulations also ensure that all due process protections provided in the Administrative Procedure Act found in the California Government Code will apply to your hearing. The hearing will be recorded by a court reporter who will prepare a transcript of the proceedings. You may make arrangements with the court reporter to order a copy of the transcript following the hearing. The AHB's hearing rooms are accessible to persons with disabilities. If you or persons you expect to attend the hearing have special needs that require reasonable accommodations, please contact the AHB as soon as possible. Remember, the hearing is your chance to tell the ALJ your side of the story, so bring to the hearing any witnesses, documents, or other material that support your case. After the hearing, the ALJ will issue an order closing the evidentiary record. Within 60 days after the ALJ issues the order closing the evidentiary record, the ALJ will submit a proposed decision that includes findings of fact and conclusions of law based on the evidentiary record and governing law. Within 60 days after the Commissioner receives the ALJ's proposed decision, the Commissioner will issue an order adopting, modifying, or rejecting the proposed decision. If the Commissioner adopts the proposed decision, it becomes effective 30 days after it is mailed or delivered to the parties, unless the Commissioner orders that the decision becomes effective sooner. The Commissioner's authority to order reconsideration expires 30 days after service of the decision, or on a date earlier if ordered by the Commissioner. Petitions for reconsideration must be served on all parties. However, the Commissioner need not respond to the petition. You may learn more about the dispute resolution process from the California Workers' Compensation Uniform Statistical Reporting Plan, 1995, and the California Workers' Compensation Experience Rating Plan, 1995. Both of these sources are available at www.wcirb.com under Publications and Filings. In addition, the California Code of Regulations, Title 10, Sections 2509.40 through 2509.78 are available at www.oal.ca.gov. The California Department of Insurance's website at www.insurance.ca.gov also is a good resource for obtaining information about the dispute resolution process. Select the Consumer tab on the CDI's homepage and then select the links to Administrative Hearings and Public Programs, Administrative Hearing Bureau. To get information about the Administrative Hearing Bureau, how to file an appeal, how to obtain helpful forms, and get answers to frequently asked questions. This presentation has reviewed the dispute resolution process, the types of workers' compensation policy disputes the Insurance Commissioner will decide, the types of workers' compensation policy disputes the Insurance Commissioner will not decide, how to initiate the dispute resolution process with the WCIRB or an insurer, how to appeal an adverse decision by the insurer or the WCIRB to the CDI's AHB, general hearing procedures, and reference materials about the dispute resolution process. Thank you for visiting CDI's website.